Good afternoon, and welcome to a webinar on understanding the role of a qualified individual, hosted by EAS Consulting Group and presented by Independent Advisor for Import Operations, Dominic Veneziano, and Independent Advisor for FSMA, Charles Breen. EAS specializes in FDA regulatory matters with a prime focus of assisting domestic and foreign food, pharmaceutical, dietary supplement, medical device, tobacco, and cosmetics firms comply with applicable laws and regulations. EAS is staffed with former FDA compliance and inspection officials and industry executives and is assisted by an extensive network of consultants with many years of FDA and industry experience. Today's presenters are Charles Breen and Dominic Veneziano. Charles Breen has had a distinguished career at FDA, working in areas such as HACCP, LACF, and BSE prohibitive materials and dairy. Mr. Breen has worked with industry on compliance issues relating to Bioterrorism 2003 and led the field and headquarters professionals in developing and implementing surveillance and compliance programs and initial FSMA training and implementation. His attention to detail has garnered him an FDA Award of Merit, Outstanding Achievement, and 5 Commissioner Special Citations. Dominic Veneziano is a veteran FDA specialist with over 24 years of agency experience. He worked as director of FDA's Division of Import Operations for more than 10 years. In that role, he was responsible for oversight of FDA import operations and import operation programs and provided leadership, guidance, and direction to approximately 1,000 field investigators in more than 320 U.S. ports of entry. He also served as a co-lead in the development of the FSMA import regulations and was senior advisor on the implementation of FSMA and FDA Food Safety, FDA Safety and Innovation Act. As a reminder, during the webinar, you may ask any questions of typing them into the questions box. And with that, I'll turn the presentation over to Charles.
Hello, and thank you for joining us today. Dominic and I are going to be discussing what a qualified individual is and how to use the skills of a qualified individual in the application of FDA's Foreign Supplier Verification Program. And the agenda we'll be covering today, once I can get, there we go, regulatory requirements, what a qualified individual is. And related to that is a qualified auditor and verification activities that would be conducted to execute a Foreign Supplier Verification Program. We're also going to be addressing questions and answers related to these. First of all, a qualified individual is required to have the education, training, or experience necessary to do the required activities. And the required activities are pretty much what would be decided upon by the qualified individual and the company for whom goods are being imported. One of the key elements of a qualified individual, though, is to be able to read and understand the language of the records that would be reviewed in the execution of the duties of a qualified individual. FDA kind of danced around whether or not the records would be acceptable if translated. I believe that translated records are appropriate for qualified individuals to read if the translation is done by someone who is fluent in both languages and knowledgeable in the facility that's manufacturing the goods. A qualified auditor is also someone with technical expertise, obtained again, education, training, or experience to perform auditing. And there must be some auditing experience there to qualify. It cannot just be someone who knows the industry. It has to be someone who knows the industry and knows what auditing is. Now, the auditor can be a government employee, including a foreign government, or certified by an accredited certification body. FDA has accredited I think 3 certification bodies, and auditors are or are in the process of being certified through the certification bodies to perform audits of facilities at the request of an importer usually, to determine the conditions and practices that that facility with the food safety requirements and other requirements of the Food and Drug Act. Now, this is all to support the Foreign Supplier Verification Program. The qualified individual, or a qualified individual, and there can be more than one for any operation, will require any further manufacturing steps upon entry into the country, and not require any cooking or other preparation steps by the consumer to eliminate any hazards. The food is considered by the agency to be high risk, and one of the means by which an importer can determine that this is a suitable firm to buy stuff from is to have an on-site audit made by a qualified auditor to make that evaluation in the foreign facility. Now, the qualified individual has to prepare the Foreign Supplier Verification Plan. And in doing so, they have to prepare a hazard analysis or review the hazard analysis prepared by another qualified individual of that food manufacturing facility. The word "or" is important here. For the Foreign Supplier Verification Program, there is a lot of flexibility in how the plan is executed. The result is what FDA is after. The result is assurance that the food being imported is provided for by the domestic enforcement program. So the hazard analysis can be prepared by a qualified individual, or a qualified individual can review a hazard analysis prepared by someone else who is qualified, such as the manufacturing firm's quality assurance department. But there needs to be some documentation to that the people who are doing it are qualified. And on the Foreign Supplier Verification side, the qualified individual has to document the hazard analysis review. The qualified individual can conduct, and in fact must conduct, a review of the foreign supplier's food safety records, inspections by national authorities within the country where the manufacturer is located, certification audits by non-regulatory certification schemes such as FSSC 22000, BRC, and similar non-regulatory schemes that certify a manufacturer to be in compliance with the scheme that is the subject of the audit, to determine whether or not the evidence is good enough to support the import of food into the U.S. from a manufacturer. Now, if sampling is required, if is another word here, just like "or," if sampling and testing are a part of the FSVP plan, the testing must be done by a qualified individual. For testing, this would probably be an analyst who has the training and background to perform the analysis that is requested. If it's for the presence of pathogens, then the testing laboratory has to be able to provide documentation that they're suitable to perform the analysis. Or a third party can perform verification activities, as long as the qualified individual working for the importer knows of and can verify that the activities were done by a qualified individual. Again, it's back to the same point I made earlier. FDA is less concerned with the actual mechanism by which these obligations must be met, and more concerned with the result, and that the steps in the process in between are properly documented. Qualified individuals must not have any financial conflicts of interest that could influence the results of their evaluation. If the qualified individual is a third party, such as EAS, EAS consultants don't have a financial interest in whether the answer is yes or no, and a employee of a firm has to be protected from retaliation should the employee say, no, this supplier isn't any good. That decision, that evaluation by a qualified individual has to be supported by the company that is wishing to import from an exporter. Importing high-risk foods is where I mentioned qualified auditor earlier. The qualified auditor may do an on-site audit. Whether or not an on-site audit is necessary is up to the qualified individual to decide. The default position of the Food and Drug Administration is that high-risk foods should have an on-site audit. But a qualified individual may be able to document that a high-risk food may be imported without an on-site audit if the information that is provided to the qualified individual for evaluation is sufficient to answer the questions that arise when you are importing a high-risk food. This is an evaluation that somebody has to be pretty good to be able to make, to decide that a high-risk food does not need an on-site audit. Now, when a qualified auditor does perform an on-site audit, the auditor must be able to document findings and include any corrective actions that were found for any deficiencies, significant deficiencies at the manufacturing facility. The records of a qualified auditor in this documentation will be available to the Food and Drug Administration when the audit is conducted for the purpose of making a determination that this foreign facility is producing food that is good enough to be imported into the United States. And FDA will most certainly be looking at whether or not any significant deviations from the regulations were found and how quickly any corrective actions were made to those deficiencies. Now, that was a really pretty brief introduction. I'm going to turn it over to Dominic now.
Thank you for going over the regulations. The regulations, obviously, for a qualified individual and a qualified auditor isn't very complicated and isn't very long compared to the rest of FSVP. But what we wanted to do is open it up to questions. And we have an over, but if you have additional questions, please feel free to write them down, and we'll see them on screen and we'll answer them as we go. But just going to go through them and provide some answers to these, and perhaps they're going to answer some of your questions as we go. So, what kind of education, training, or experience should a qualified individual have? It actually depends on the information that you have and where you got your training. So the education, training, and experience, it just has to be a combination of them to be qualified for the work that the individual is going to be doing. And there's so many different types of combinations that the agency never wanted to identify what is actually required to be a qualified individual. So technically, as long as you have the capability or you have experience in performing the functions that you're doing, you would most likely be a qualified individual. And again, if it has to do with conducting hazard analysis of a food, then the individual should have either taken classes or attended seminars on the principles of hazard analysis. And that goes for, as Charles mentioned earlier, if the individual is going to do sampling or testing of a product, then obviously there has to be a combination of how to run that test and how to read lab reports in order to meet that requirement. So just that overall, it's just the agency didn't want to pinpoint, but there are also classes that you can attend. One of them obviously is from FSPCA courses on how to develop an FSVP, as well as the preventive control regulations on hazard controls. Somebody may also on hazard analysis for seafood, and that may be pertinent to the work that's being done under this FSVP or the product that's being imported. So a lot of different ways to be a qualified individual. Second question is, does the education, training, or experience for a qualified individual have to be attained in the United States? And the answer is no. It can be obtained anywhere as long as they have that combination of education, training, and experience. Should also mention that most likely during an inspection by FDA, they're not going to ask for the documentation to demonstrate that somebody has been qualified. What they may do, though, if there is issues with your FSVP, that's when they may ask about who did the qualifications or who did the review, and then bring up and ask, how did you know they were qualified to do that work? So, overall, they're not going to ask for the documentation, but if there's issues, then they may. They always have the right to ask for that information to demonstrate that the people that are doing the work are qualified to do that work. What language skills must a qualified individual have? Charles touched on this very nicely. It depends upon the work that's doing. They have to have the capability of reading the work that they are doing. So if you're going to keep your procedures and your policies in Spanish, then obviously the individual has to speak Spanish or be able to read Spanish in order to make a determination on whether the documentation is good and effective. Are there any restrictions related to conflict of interest associated with it? And the answer is yes. Charles touched on this briefly. And if you look at the regulations 1.506E, and very simply, that it cannot be a financial interest on the results of a decision of that qualified individual. So if you are you can't increase somebody's pay if they find everything in order, and you can't decrease somebody's pay if they find it out of compliance. So 1.506E talks specifically about what the requirements are in terms of conflict of interest, but pretty simply, there just cannot be a pay-to-play, if you will, situation where someone's getting paid for the results of those of the review that's being done. Can a U.S. or a foreign government employee be a qualified individual? The answer is yes. A U.S. or foreign government employee who is a qualified individual may conduct FSVP-related activities. So you may rely on the results of an audit or an inspection of a foreign supplier conducted by the USDA, for instance, Department of Defense, as long as the audit or inspection considers applicable FDA food safety regulations and meet the other requirements of audit. So if your supplier actually went through an FDA inspection, you can utilize that as an audit being done by a qualified individual. Next slide. So looking at the auditing, Charles talked about the differences between a qualified individual and the qualified auditor, and when you have to use both. Just a qualified auditor, again, has the combination of education, training, and experience necessary to perform that function. And there are there's main reasons for doing an audit. One has to do with a cicada hazard. So if you identify a hazard that causes serious adverse health events to humans or animals, then the FDA is looking for an audit, an on-site audit to be conducted to prevent that hazard. And the person that should be doing that audit has to be a qualified auditor in terms of education, training, and experience. The other aspect is on, as required under the regulations, 1.506 talks about on-site auditing, as well as 1.511 for dietary supplements. One of the requirements under the modified requirements is making sure that somebody is in compliance with the dietary supplements regulations of 111. And in order to do that, you have to have a qualified auditor go and do those inspections to ensure that they're in compliance with those regulations. Can a U.S. or foreign government employee be a qualified auditor? Same answer that I gave you earlier in terms of a qualified individual. The answer is yes. If a government official of CFIA or Covey Priest or SIGAPA goes in and does an inspection and they find it acceptable based upon the food safety requirements of the agency, then they would be an auditor, a qualified auditor. Can a third party be a qualified auditor? Absolutely. A third party can be an auditor who is not employed by and is independent from you or your foreign supplier. Can be a qualified auditor. A third party auditor can be a public entity as well. So in all certification program, but it doesn't necessarily have to be. Again, what kind of education, training, or experience should a qualified auditor have? Again, it is all dependent upon the work that they're doing, but the agency hasn't identified specific courses or programs or certifications that a qualified auditor must have to complete. But they expect that a qualified auditor have, again, the education, training, or experience that provides the person with knowledge and skills necessary to evaluate whether the equipment, processes, and procedures in a food facility or on a farm ensure that the hazards associated with the food are significantly minimized or prevented. Again, they have to have experience. If they've been in facilities and doing internal audits for a company for many, many years, that would qualify as an individual being capable and qualified to do an auditor. I touched briefly on this. When must I use a qualified auditor? Again, there were a couple of things specifically. So you must use a qualified auditor to conduct an on-site audit of a foreign supplier as a verification activity in accordance with 1.506 or 1.511. There must be documentation that the on-site audit was conducted by a qualified auditor, including when you rely on the results of an audit. So even if you review someone else's work, a third party's work, or another government official's audit, you still have to use a qualified auditor to go through that audit to ensure that they covered everything as it's required under the FDA's food safety requirements. So very briefly, that's a number of questions. Next slide. That's just a couple of questions and answers that we have. We're happy to answer any questions that you might have that we haven't thought about. I know that the guidance document the agency put out is very helpful in terms of looking at not only all of FSVP requirements, but for the qualified auditor aspects. And when the agency put that document together, we put it together with the idea of what questions might people have. So we hope that we answered a lot of your questions and provided you with significant information related to what is actually needed in order to be a qualified individual and auditor. And if we can open it up to questions, we're happy to do that.
Absolutely.
Yes, we'd be happy.
Oh, sorry. Go ahead, Charles.
I was just going to say, we know that the very flexibility of the Foreign Supplier Verification Program and what a qualified auditor or a qualified individual is or does means that there's a lot of choices that a firm can make, has to make, in order to decide what's appropriate. So the details matter. The framework from FDA is the same, but how you execute it really depends on your details. And we'd be happy to address as many questions as we can in the time remaining.
Our first question is just a better definition of what is a high-risk food.
Yes. High risk is the agency has a somewhat flexible definition depending upon when it wishes to apply its resources. But in general, it is one in which the consumer buys a finished food and eats it without any prep. So canned tuna is a food that is often consumed without any further preparation. But is it high risk? The answer is maybe. If the canned tuna is being produced in a facility that complies with the canned food regulations, then right out of the can, it's not going to be a high-risk food. But if it's used to make tuna salad or something like that, the risk factor then goes up because it's exposed to different ingredients and different an environment. An easier example would be a raw milk cheese imported somewhere in Europe. Raw milk is a high-risk food because it not only can support pathogens, it does not have a kill step applied to it to prevent those pathogens from causing illness. A properly made cheese has steps built in for aging with the proper acidity and moisture content to control, to eliminate or minimize pathogens. So how a high-risk cheese is made is, in my opinion, very much one that should have serious consideration given to whether an on-site audit takes place. I hope that helps provide some information on that. And Dominic, do you have more you'd like to add there?
I think you covered it really well, Charles. The only thing I would add is obviously ready-to-eat products are the highest risk that they have, and that's what they're going to focus on in terms of things that can make you sick. Anything with a hazard with E. coli, salmonella, or a pathogen that causes death or serious injury, you should be concerned with and be focused on.
Our question is a QI.
One more point.
Oh, sorry.
Amy, there's one more thing I want to mention about high-risk food and ready-to-eat. There are some ready-to-eat foods, though, that are not necessarily high risk. Baked goods, cookies, crackers, and so forth may not be considered high-risk foods, although ready-to-eat, because their product characteristics do not support the growth of microorganisms. So ready-to-eat is a first cut, but the second cut has to be whether or not it will support the growth of harmful microorganisms.
Okay, thank you. Sorry for interrupting. The next question, does a QI or QA need to attend an FSVP certification course?
Are they required to? No.
They're not, but just be aware that under the preventive control regulations, there is a requirement that you may take the FSVPA course that is recommended.
Yes, recommended is a key word there. It's not required for a preventive controls qualified individual, but it is advised. For the Foreign Supplier Verification Program, there is no formally accepted protocol or curriculum because the range of foods is so broad. Someone evaluating dairy food would not necessarily be competent to evaluate dietary supplements, but they're both covered under the Foreign Supplier Verification Program. So it would depend on the food being imported. But there are courses that what's it called? The Food Safety Program Alliance puts on to help familiarize people with the requirements of the Foreign Supply Verification Program that can help.
Our next question, what is the responsibility of brokers versus manufacturers? If a U.S. company is buying from a U.S. broker importing foods, what information is required from the broker to comply with this regulation?
It's a contractual matter between the importer and the broker. FDA will hold the importer responsible for determining the safety of the food being imported. If the importer cannot get that information from the broker, the importer has to go somewhere else, either a different manufacturer or a different broker. The contracts I've seen lately, oftentimes from a broker, say, we're not responsible for the Foreign Supplier Verification Program, that's all on you, the importer. So the importer has to know from whom these items are being received. Some brokers might be a little reluctant because this could cut them out of the loop. It is an issue that's ongoing, and it's one that, as the importer, you have no choice. You need to know that the food being imported is safe. The broker has a choice to do it or to relay information to you. If the broker is relaying information to you, it's probably along the lines of, we get it from this manufacturing plant, or maybe this one over here. And sometimes they'll use that one there. There has to be information about all of these different facilities sufficient for the importer to evaluate to determine whether or not it meets U.S. requirements and is safe food. I expect to see changes continuing through the industry as this progresses.
Just remember that the definition of the importer for FSVP purposes the U.S. owner or consignee of an article of food that is being offered for import into the United States. And if there is no U.S. owner or consignee of an article of food at the time of entry, the importer is the U.S. agent or representative. It also has to do with who purchases the food at the time. So if the broker purchased it from a supplier, then by definition, they may be the FSVP importer as well as the importer. So the guidance document talks a little bit about the fact that there may be two FSVP importers at the time, and then contractual, as Charles was mentioning, they're going to have to work out as to who is actually responsible for that, maintaining the FSVP and ensuring that the product being imported is in compliance and not adulterated. So you have to understand the flow, the supply chain flow of the product and who is purchasing it and what commitments have been made. But there may be two at that time of entry.
And the importer for FSVP program is not necessarily the same as the importer of record for Customs and Border Protection. So FDA's importer can, but doesn't have to be the same as Customs and Border Protection importer of record. For Customs and Border Protection, the importer of record is the person responsible for paying any tariffs. For FDA's Foreign Supplier Verification Program, the importer is a different, or has different responsibilities.
Our next question, are there any minimum requirements for a qualified individual for any part of FSMA?
That they know what they're doing is the bottom line, that they have the education and training that they are tasked with evaluating. The example I used earlier, you wouldn't, a person who knows dairy may not be capable of evaluating safety in a shrimp import. So it has to be enough knowledge, training, experience, or any combination of them to have the skills to do an evaluation, to do a hazard analysis, to document what's required to show the food complies with U.S. regulations.
Okay.
So there is no minimum, but you have to be more than the guy who drives the forklift.
Okay, thank you. Is the qualified individual only reviewing records, or are they part of the process that oversees the foreign supplier?
It can be both. It can be just records review, or it can be the entire process up to and including on-site auditing if the qualified individual is also able to be a qualified auditor.
And what is the responsibility of a distributor that buys an imported food from an importer?
Again, it goes back to... Go
ahead, Dominic.
Again, it goes back to whether the distributor is acting as the FSVP importer or not. If they're buying the product and they're responsible for, and if they meet the definition of the FSVP importer, then they're responsible for implementing a Foreign Supplier Verification Program for that product, from that food. Again, they would have to work with, if they're distributing it to somebody else and that their customer buys the product and the purchase order is from the, if you're bringing in the product for distribution, then you are responsible for the Foreign Supplier Verification Program.
The next question is a two-parter. Is a DUNS number necessary to sell or import into the U.S.? The second part, what does a U.S. agent for FDA need to do? And Charles and Dominic, as you answer that, you may want to just share a little bit about services EAS provides as a U.S. agent.
Okay, so I'll take the first.
Go ahead, Charles.
The importer must provide a unique identifying number to the agency to, well, identify the importer. Right now, the only unique number for identification that FDA recognizes is DUNS number. So that's a bureaucratic way of saying, yes, a DUNS number is required of the importer in order for the agency to know who is responsible for the FSVP obligations for the import of that food. You want to get the second part, Dominic?
The second part had to do with
just discussing what the roles of a U.S. agent is.
Yeah, so under the Bioterrorism Act of 2011, the agency required that when a foreign company who manufactures, holds food, registers, you have to identify a U.S. agent. That U.S. agent's responsibility is to be available to the agency if the agency has any questions related to an entry or can't get a hold of the manufacturer at any time. Under FSMA, that role changed. There was a couple of requirements under FSMA now that put some onus on the U.S. agent, which included re-examination of an imported product or a re-inspection of a violation, or a follow-up to a violation inspection. So an inspection that was conducted overseas of a supplier or a manufacturer that was found OAI, which is official action indicated, and was issued a warning letter or something more serious. If the agency went back to conduct another inspection, then they could charge the U.S. agent for the re-inspection fees. The agency, however, never implemented and moved forward with that aspect. It's in the law; they have the right to do it, but they have yet to do that. But the way it was written is the individual that they would charge would have been the U.S. agent. We want to make it clear that the U.S. agent, under the definition of the FSVP importer, is not the same as the U.S. agent under the Bioterrorism Act. What we wanted to make sure that they did is when you assign someone, if there isn't an owner or consignee at the time of importer and somebody has to identify an FSVP importer, that U.S. agent is not the same agent under the Bioterrorism Act requirement. It is someone who has the capability of and is a qualified individual to implement a foreign supply verification program. So it could be the same if they have that capability, but in most cases, in my experience, it will not be the same. Just a little bit about EAS in the would register a company as well as serve as that U.S. agent under the Bioterrorism Act as well. So I hope that answers the question.
It does, thank you. And if anyone has any last questions, if you would just send them in quickly. We'll hold a couple more seconds here.
While we wait, I'll just, my over the past, since it really came into effect in 2007 when the dates came, when full implementation have heard, there's been a lot of scenarios that I've heard through and advice that has been given to FSVP importers and to individuals. I just want to stress that it's very important to get somebody that understands what the laws say and what they mean, because I've seen people come to me that were given wrong information, and it could lead to, although the agency has used education before regulation as of now, in FY 2019, I think the agency has to move to more of a compliance role, especially if they do follow-up inspections. And getting the right information and understanding what those regulations are is critical to you and your organization. You don't want to be on the end where you're being given a warning letter, or you're being placed on an import alert as a result of not understanding the FSVP requirements. So I just wanted to put it out there while we wait for questions.
Right.
And let me observe that FDA has been making inspections of importers, and they've been finding deficiencies in quite a few. In fact, 40% of the inspections that have been made of importers, the deficiency found is no FSVP plan. So the agency's patience will run out. We just don't know exactly when.
Okay, thank you. And someone in the audience asks if you can just briefly hit the highlights again of what a qualified individual must, and they have must in capital letters, be doing with a foreign supplier.
Yes. The qualified individual is responsible for developing the Foreign Supplier Verification Program plan, for evaluating somebody else's hazard analysis for that facility, or conducting the importer's own hazard analysis, and determining whether or not the information available to the qualified individual is sufficient to document that this food is safe to import into the U.S. and that it meets FDA requirements.
Okay, great. So in our follow-up email, I will send everyone some information on EAS services as a U.S. agent, if that is of interest. I'll also send some additional information on services with regards to FSMA, Foreign Supplier Verification Program, registration and listing services, and then a brief video that just discusses a little bit more about FSVP and qualified individual, and hopefully those will be helpful to everyone. So if you have any additional questions, feel free to always contact EAS. We thank you all very much for your attendance today and hope this has been of benefit, and we look forward to seeing you at a webinar in the future. Thank you.